Good morning. This is the continued hearing in the Supreme Court of the United Kingdom of the appeal by Shagang Shipping Company Limited in liquidation and HNA Group Company Limited. We are currently hearing the submissions of the respondent, and I invite Mr. Edward Brown to continue his submissions.
Thank you, my Lord. My Lord, before I continue, I want to be clear as to what targets we understand that we are aiming at on this appeal and how they relate to the disposal of the appeal. Shagang's issue 1 is whether the criticisms made by the Court of Appeal of the reasoning of the judge were justified. Shagang says that the Court of Appeal stepped outside its remit under CPR Rule 52.21 in deciding that the judge's conclusions in respect of bribery did not have an adequate foundation. That is the new ground for which permission is sought. Shagang's issue 2 is that the scope of remittal was wrong in light of what was found in respect of torture. And Shagang says that the remitted case should encompass torture. That is principally by reference to the submissions made in relation to Read B and A number 2. I'm proposing now to focus on the first issue, and I had begun to address that yesterday by showing you what the Court of Appeal decided and why. What I'm going to go on to do is to show you in detail what the judge said in his judgment, in particular in relation to the 9 factors, and to explain why the Court of Appeal was right to take issue with the judge. I hope that will be a convenient moment to address further the various points of detail that the court was putting to me yesterday. But before I do that, can I make the following remarks? We recognise entirely that the judicial instincts of every appellate judge when he or she has first looked at this appeal is one of healthy scepticism. So see, please, the permission decision of Lord Justice Davis, which you have been shown, which is at MS 248. One sees from the permission decision there, and as recorded at 248, that is a decision made without an oral hearing on the papers. So see the top of the page, that Lord Justice Davis considered that the permission to appeal application did not even cross the threshold for permission. It was not arguable. And one sees the reasons that were given by the learned judge at MS 250. See, please, paragraph 7, which encapsulates the points about the market rate, etc., which are part of Shagang's 9 factors. See too, please, what the judge said at the top of MS 251. So the judge says, 4th line, the judge clearly accepted the evidence of Mr. Guo in this regard, and he was entitled not to attach weight to the confessions and plea as showing the truth of there having been bribery. His reasoning may have been terse in this regard, but it was sufficient. And to some extent, that encapsulates some of the points that the court had raised with me yesterday. And yesterday, the court will recall that Lord Burrows fairly encapsulated the point by putting to me that HNA indeed accepts that weight is a matter for the judge. There was indeed some analysis of weight by the judge, even if it is terse. And my Lord Burrows asked rhetorically, what then is HNA's actual complaint? Lord Justice Longmore adopted the same approach at the oral permission hearing. He made precisely the same point, but with the benefit of oral argument, recognised that the threshold was indeed crossed. And in so doing, he accepted that this was perhaps not as clear as it appears at first blush. I was at that hearing. Please take it from me that his lordship's initial response was the same as that of Lord Justice Davis, namely that there is nothing to see here, no arguable appeal. He was persuaded to depart from that provisional view, and of course, with permission, the exercise becomes somewhat different. So the appellate court's job, when permission is granted, is to conduct a review of the process of analysis and reasoning, building into that review necessary deference to the trial judge. And that was the exercise at the full hearing before the Court of Appeal. And it is right to recognise that the Court of Appeal too started from the same position. So see please MS 408, which is an extract from the transcript of day 1, and it begins at page 9. So right at the start of the oral submissions on the appeal. We only have one page, but it is enough to get a flavour. So one sees from page 9, in the exchange between the Chancellor and HNA, that immediately HNA comes under some heavy fire from the bench. So if one picks up the Chancellor, please, at page 9, line 25, Lord Justice Voss, well, the judge gives 3 reasons, doesn't he, why the admissions are not reliable. Mr. Smoohar for HNA, and I'm going to go through those, my lord. He doesn't give 3 reasons why the admissions are not reliable, but I'm going to, and then HNA say that they're going to go through it. And then the Chancellor says this: do we read the judgment as a deed? So I mean, this is a factual judgment where he reaches a conclusion which is clear, and it is open to you. I mean, the view I always take about factual appeals, Mr. Smoohar, is that you have to get your screwdriver in, if I can put it that way, to the judgment to show that the judgment is basically wrong on the factual matter, or sustainable, or whatever any of the cases may show. And your attempt to do that, as far as I understand it, is just this binary point on torture. And to me, anyway, at the moment, I don't really see how that works for you, because I do not see why the judge was not entitled to say, well, I don't know about torture, I haven't got enough evidence, which is hardly surprising, but taking the admissions, taking the plea of guilty, and taking all of the other factors and weighing them all together, I come to the conclusion that there wasn't a bribe. How do you get your screwdriver into that? HNA give some provisional responses to the Chancellor at the top of page 11. And what I note is that this very experienced Court of Appeal has exactly the same concerns as troubled Lord Justice Davis, Lord Justice Longmore, and are no doubt in the minds of this court too. But the point is that these are high-level points, and this is an appeal which requires a granular approach. This case does require the Chancellor's screwdriver, and we accept that. So our headline submission, before I look in more detail at the 2 judgments below, is this: our complaint is and always has been fundamentally about reasoning. The judge's job was not just to decide bribery. His job was to reason through the admissions evidence properly, giving cogent reasons to the parties so as to provide a proper foundation for his conclusions on bribery. That is his obligation as a matter of ordinary judgment writing, and I will show you Lord Justice Mayall's judgment in Symmetra in due course. We accept that the judge did part of his job. He decided bribery, and he made some findings, including findings on torture, and we'll look at that. And we accept that the judge had some factors in mind that go to the weight to be given to the admissions, confessions, evidence. But we say, for the reasons that the Court of Appeal gave, this fundamentally was inadequate in this case. And to make that good, we need to look at the Court of Appeal, which is MS 191. So one has the Court of Appeal's judgment, and what one sees here is the journey that the Court of Appeal embarked on from the morning of the 26th of June 2018, which is the transcript reference that I have just shown you, to its reasoned and cogent reserved judgment on the 23rd of July 2018, which deals with every single point raised on appeal by HNA and Shagang, and which, for Shagang at least, are repeated verbatim in its appeal before this court. So one sees that this is, from MS 192, a combined judgment of the Chancellor, Lord Justice Newey, and Dame Elizabeth Gloucester, highly regarded and experienced commercial judges. And they say this, they pick up the issues at paragraph 4 of the judgment. So having set out the background, say, in addition to the issue just described, the central issues between the parties resolved themselves into whether the judge had been justified in deciding the issue of bribery first and the issue of torture thereafter, comma, whether he had provided sufficient reasons for rejecting the reliability of admissible admissions, comma, and whether the Court of Appeal could or should interfere with his evaluation of the agreed primary facts. So those were the issues before the Court of Appeal, and fundamentally those are the issues in respect of issue 1 before you now. See please paragraph 8 of the Court of Appeal's judgment. The Court of Appeal acknowledges that HNA's case was founded on admissions of bribery. Then, having provided further background, at paragraph 17, the Court of Appeal sets out in some detail the circumstances of the confessions of bribery by Mr. Zhu, Mr. Giatti, and Mr. Shen. Paragraph 21 addresses the point about Mr. Zhu's confession on the 4th of March 2014 and notes in terms the specific reference to leniency. So see please the final sentence. He answered that his initial account had been false and that he had subsequently confessed the full extent of his crimes for leniency. Paragraph 24 picks up the issue of the amendment of the pleadings, so how it is that the allegations translate into issues in the case. And the Court of Appeal correctly identifies from the 5th line of paragraph 24, HNA pleaded that it would rely on the confessions of Mr. Zhu, Mr. Giatti, and Mr. Shen. HNA then pleaded that it was entitled to rescind the guarantee due to Shagang's fraudulent non-disclosure of the bribery, or alternatively that the bribery meant that Shagang's claim was barred by the illegality principle. And then paragraph 25 records Shagang's response to that, namely charged party being procured by bribery, but without alleging that the admissions had been procured by torture. Then ultimately further amendments. But before I show you that, if I can just ask you please to consider paragraph 27, which then details Mr. Zhu's interview and confession on the 21st of August 2014. So that records the fact that Mr. Zhu did say the opposite to what he had originally confessed. So he did say that he had not in fact committed bribery, and furthermore, he did make allegations of torture. See also paragraph 28, encapsulating the further torture evidence, and then paragraph 29, which deals with the pleadings. The pleadings are set out in some detail. This was a commercial case, and the pleadings do encapsulate the points that the parties were advancing before the trial judge. What the Court of Appeal does next is to turn to the judge's judgment, paragraph 33. That records the material parts of the judgment, and as I'm going to address the judgment next, I'm not proposing to deal with that here. But the Court of Appeal then, from paragraph 44 through to 50, identifies the issues on appeal. That records HNA's grounds, Shagang's respondent's notice, see paragraph 46, the application to reduce new evidence, paragraph 47 through to 49, and then summarises the issues as the Court of Appeal sought to take them. Paragraph 51 addresses DATEC. I'm going to make submissions on that. And paragraph 54 then deals with read B and A number 2. And I'm going to take those issues secondly because Shagang has effectively relegated those to issue 2 and remittal. So I'm going to park the debate about read B and A number 2 for now. So what then does the Court of Appeal actually conclude and why? So paragraph 63, the Court of Appeal does indeed say that the judge ought to have determined torture first. So the Court of Appeal say, in our view, the judge ought to have decided the issue of torture first. It was the sole basis on which the admissibility of the admissions was resisted. All the other arguments went only to the weight that should be accorded to them. Thus, the judge's first task was to decide on the facts whether or not torture had taken place in order to extract each of the 3 main admissions, leaving aside Mr. GOH, relied upon by HNA. Once he had done that exercise, the judge should have stated his conclusion that since torture had not been proved, the admissions were admissible as evidence of their contents. So that's the first part of what the Court of Appeal said. So paragraph 64 then records the reasons why this might be necessary. So there's reference to section 4 of the 1995 Act, in particular sections 4.1 and sections 4.2. So picking up 10 lines down, section 4.2 then lists a number of particular factors to which regard may be had in that context. The factors are mainly concerned with the hearsay nature of such statements, such as whether the maker could have been produced as a witness and whether the evidence is multiple hearsay. Notably, however, section 4.2d points the court to asking whether the person making the statement had any motive to conceal or misrepresent matters. I accept, as the court put it yesterday, that fundamentally the task of weighing hearsay evidence is no different from the task of weighing other evidence, including direct evidence. In any case, the judge needs to ask himself what weight to attach to the evidence, having regard to all of the circumstances. So all that section 4.2d really does is establish by statute the fact that these sorts of questions would almost invariably arise when analysing hearsay statements of this nature. Paragraph 65 summarises what the tasks for the judge were. So the Court of Appeal say this: in our judgment, therefore, the proper approach in a case of this kind is to decide first whether torture is proved. If it is not proved, as in this case, the statements are admitted as hearsay evidence. The next step is to decide the weight that can be attached to that evidence in all the circumstances, including those in section 4 of the 1995 Act. Only then could the court properly move on to an evaluation of all the evidence, including the hearsay statements of admission, in order to decide the primary factual issue in the case, which was whether the alleged bribery occurred. We can quite see that the second and third stages of the process might be undertaken together, but it must be clear that both have actually been considered. So, my lords, the tasks are threefold. Task 1 is to decide admissibility. Task 2 is to decide weight in all the circumstances, having regard to section 4. Task 3 is to evaluate the evidence, having determined the issues of weight, so as to decide the issues in the case. There is nothing wrong with doing task 2 and task 3 together, but it must be clear that both have actually been considered. That, we say, means clear on the face of the judgment and on a fair reading of the reasons given by the judge. So HNA, as a customer of this court, is entitled to know why it has won or lost. That's not just reasons for their own sake, but reasons as evidence that the necessary questions have been asked and answered by the judge. So fundamentally, we say, The question before the Supreme Court is whether the Court of Appeal was right or wrong in its articulation of the three jobs in paragraph 65. Because if the Court of Appeal was right, for the reasons that the Court of Appeal gives in a moment, it is clear that the judge did not properly ask or answer the second question about weight. No, my Lord, Lord Legate.
There's nothing wrong in principle, is there, Mr. Brown, although it may not commend itself to the Chancellor as the best approach, there's nothing wrong as a matter of law with treating evidence as admissible de bene esse, deciding that even taking account of that evidence, the case isn't proved, and then concluding that you don't actually need to resolve the question of admissibility in the light of that result.
Yeah, I accept that. So it is possible, and Shagang's case of advance on this appeal is that that's what the judge did. And the difficulty that we have is that that isn't revealed by the judge's judgment. He doesn't say that he is approaching issue 1 de bene esse. And I'll come on to what he does say about issue 1, i.e. admissibility in due course. But it isn't, we would say, a fair reading of what the judge actually was doing here. It might be, in principle, a fair way of doing it. I don't say it isn't.
So it's not necessarily the proper approach to decide the question of admissibility first. There's an alternative approach, at least in principle, available.
Yes, there is an alternative approach, but it's not fundamentally all that different from what the Court of Appeal is saying. Admissibility needs to at least be considered properly. If the judge is going to say, well, for the following reasons, I am entitled to do admissibility de bene esse, then one can see that that might not be objectionable if the judge says that's what he's doing, and if there's some good reason for doing that. So I don't disagree, my Lord, with the proposition as put to me. It's just not what the judge did here. Now, why is this important? So where does this all go? And the reason is this. So the judge has his scales before him. On one side of his scales, he is placing the admissions, and they tend to suggest bribery. On the other side of his scales, he is placing things like market factors. In order to determine where the scales come down, he needs to at least work out what weight to give to the admissions. We do not know from this judgment how or why the various factors push the scales down one way or another. So to put it another way, we do not know how much weight the judge has given the factors, and in particular, the admissions evidence. And we say, in fact, it goes further, because we don't know if the judge has actually even decided weight at all. We don't know if he has done the second job, or whether he has simply moved straight to his third job of deciding bribery. Now, picking up what the Court of Appeal say about all of this, so I was at paragraph 65. From paragraph 66 to 68, the Court of Appeal rejects as too ambitious HNA's argument that the judge ought, in fact, to have found bribery, and we accept the analysis of the Court of Appeal in those paragraphs. The paragraphs 69 to 72 concern infection. I'm going to deal with that later. But it is important to note paragraph 73, which records that so far, even considering infection, HNA hasn't won the appeal. On the basis of what we have said thus far, if the judge properly evaluated the weight to be accorded to the admissions and the other evidence, and decided the question of bribery taking into account the other relevant factors, it would, on the principles we have outlined, be inappropriate to interfere with his decision. And those principles are DATEC and the other authorities, which I'm going to address later. Now, paragraph 74 records HNA's main challenge. So HNA's main challenge under this heading was that the judge simply never asked the right legal question, namely what weight he should attach to the admissions. Had he done so, a range of other questions would have come to mind. For example, how relevant was it that there were 3 or perhaps 4 relevant admissions? What was the detail of those admissions, and how did they tally with one another? What reasons could there be for the individuals each admitting a bribe giving details that were entirely made up? And what was the relevance of the offers of leniency that had undoubtedly been made to the individuals before they made the admissions? HNA submitted that the judge instead simply moved to the ultimate question of whether there was bribery, disregarding the admissions on the flimsiest of grounds. Paragraph 75, the Court of Appeal records Shagang's submission that that's all very unfair, which is essentially their submission before the court here. Shagang say that the judge did have his scales before him, and he had regard to the 9 factors on which they rely. And they say ultimately in the round, despite the terse reasoning of the judgment, on the scales, no bribery outweighed bribery. Looking at how the Court of Appeal then analysed all of that, paragraph 76 records a submission of Shagang which was reflected in ground 2 of the permission application before this court, on which permission was refused. So paragraph 77 then directly concerns the judge's second job, i.e. the analysis of weight. And the Court of Appeal says, in any case, the judge's treatment of the weight to be given to the admissions was inadequate. As HNA submitted, he did not really address the point at all. He seems to have omitted that step in the argument. Once he found that the admissions had not been obtained by torture, if he was going to reject them as unreliable, he needed, in our judgment, to say why he was doing so. There are a number of reasons why he might, in theory, have done so, and we accept that some of Ms. Rose PC's 9 points do bear on the weight to be attached to the admissions. For example, the fact that the admissions were made at all in the terms they were, the fact that Mr. Zhu pleaded guilty to a crime of bribery, the fact that the admissions were made without a lawyer present, the fact that the admissions were retracted, and the fact that leniency was offered to induce them are all factors relevant to the weight to be attached to the admissions. Moreover, at least one of the matters dealt with in the judgment under the heading Confession, Evidence and Torture, as to criminal practice in the PRC, might also be relevant, namely the finding in paragraph 70 that the expert evidence showed that a high proportion of criminal convictions in the PRC follow admissions by the accused. We can also envisage other factors connected to the detail of the admissions, the timing and their provenance, which would be relevant to the weight to be attached to them, in addition, of course, to some of the factors mentioned in section 4.2 of the 1995 Act. Paragraph 78 then refers to the 2 necessary evidential questions. So those are questions 2 and 3 from paragraph 65 of the judgment. And the court says, in our judgment, the judge's approach in the section of his judgment entitled Conclusions on Bribery was inadequate to answer the 2 necessary evidential questions. What weight should be attached to each of the admissions relied upon by HNA? And 2, was a bribe paid by Mr. Zhu to Mr. G.A.T.? The judge never addressed the first directly, took into account an irrelevant factor, namely the testing of the PSP officer's evidence, and never reached any conclusion on the relevance of leniency that was offered. Then the Court of Appeal makes some further points in respect of leniency and says this: he did not, however, say whether or not he thought in the case of each of the relevant individuals that the prospect of leniency was a reason why the admissions in question were false. There's then the further observations in respect of leniency which Shagang showed you during their submissions. But the Court of Appeal concludes paragraph 78 by saying leniency could certainly have been a relevant factor. Then paragraph 79, the Court of Appeal's judgment is this: in our judgment, the combination of the, my Lord Legate.
The point made that the judge didn't say whether he found that leniency was a reason, and it's a point you make too, is totally unrealistic, isn't it? A judge can't see into the mind of somebody and decide what actually did motivate them, and he doesn't have to. It's sufficient that you can think of explanations which make it entirely possible that that was something which influenced them, and weigh that in the scales along with all the other factors.
My Lord, in principle, yes, but there has to be some evidence in support of the possibility itself. So the
Well, there was ample here, wasn't there? I mean, we have the caution that's given in China at the start of each interview, which is along the lines of, if you confess, it may reduce the length of your punishment.
Yeah, I accept that, my lord, and I'm going to come on to leniency in some more detail. But the fundamental point is that anything is inherently possible. So is it inherently possible that a trial judge is faced with a number of witnesses of fact who are all lying? All of the witnesses might simply be telling lies in their evidence. If the judge is going to conclude that they are indeed telling lies and therefore fall to be disbelieved, he's got to say why it is. And the theoretical possibility that a witness is lying doesn't take you there.
That's not true at all, is it? It's very rare for a judge actually to make a positive finding, or certainly doesn't need to, as to the reason why a witness is lying. It's enough to think of, to point to explanations which may explain it, but that's simply one part of evaluating whether the person was lying.
Well, it depends. Our submission is that there's got to be a proper evidential basis for reaching that actual conclusion, because it is one thing to say that there is an inherent possibility that evidence is unreliable for reasons A, B, C, but it's another to say that is in fact the reason why the evidence in fact is unreliable. So take the example of a lying witness, or possibly a witness who's intoxicated or drunk. It's a possibility that at the trial, the witness is giving evidence which is untrue, or he is intoxicated. The judge knows that as a possibility because it's always a possibility. But what is the reason for concluding that that is in fact something that has occurred in the actual trial before him? He's got to go further. So it's not enough simply to point to things that are out there. And this is a point that I'm going to develop in more detail when we look at the 9 factors. Paragraph 79, though, the fundamental conclusion of the Court of Appeal is this. In our judgment, the combination of the flaws we have pointed to renders the judge's decision unsustainable. The judge did not follow the logical steps necessary to reach a proper evaluation of the admissible evidence. He failed to ask and answer the correct legal question as to what weight should be accorded to the admissions evidence. The judge ought to have said why he was unable to place any reliance on the admissions, if that was his view. The judge also fell into legal error in failing to take all the appropriate matters into account in deciding the crucial bribery issue. As we've also said, the judge failed to exclude irrelevant matters, including his lingering doubt as to whether the admissions were procured by torture, in considering whether the alleged bribe was paid. The appeal must therefore be allowed. So it's a combination of points as opposed to individual points. What I propose to do is to go through the judgment to demonstrate why those concerns were well founded. So the judgment is at
Mr. Brown, there seems to be 3 points in paragraph 79. 1, the third, carry out what you call task 2. The second is taking account, failing to take account of appropriate matters. And the third is taking account of irrelevant matters.
Yes.
Yeah. Will you be taking us through all 3 of them?
Yes.
Thank you.
So the judgment, MS210, and one sees how the judge sets the issues up at paragraph 5. So it is HNA's case that the charter party was procured by bribery and is therefore unenforceable. The allegation of bribery is founded on confession evidence. It is Shagang's case that the confession evidence was obtained by torture and is therefore inadmissible in legal proceedings. So that was indeed the essence of the case before the judge. And the case ultimately turned on the proper analysis of those 2 propositions, which we say, this is a point I will return to, were correctly treated as facts in issue by the parties and by the court. So Shagang asked the judge to exclude or reject the confession's evidence because it was procured by torture. HNA's case was founded on confession evidence. So what then were the admissions stroke confessions? So the court will recall there are three individuals who we are looking at, and the first is Mr. Zhu. So pick up, please, MS215 from paragraph 25. So Mr. Zhu, who on HNA's case paid the bribe, there are at least 5 separate admissions. So the first is the admission on the 22nd and 23rd of January 2014. See judgment paragraphs 27 and 28. That was recorded in a written interrogation record, and the reference is MS1093. That's the first confession. The second is the confession on the 4th of March 2014. See judgment paragraph 30. And the record for that is MS1123. Paragraph 31, I just make these points now because it's convenient to do so here. Liberty made some particular observations in respect of what is recorded in paragraph 31, but we respectfully say that those observations do have the potential to be unfair, because we accept what is said about how that reads to English eyes. But note, though, that the commercial court frequently deals with foreign parties, it deals with translations of documents into English, and it deals with cultures that are different. There was no evidence that this particular formulation, which I recognise is striking to an English human rights lawyer, is actually an evidential indicator of anything at all. Paragraph 32, important, no lawyer at those 2 interrogations when the confessions were made. Thereafter, a lawyer was engaged. So one starts to see from the judgment how the issues of weight begin to emerge in the judgment. But recall, please, that on the judge's approach, torture is set aside. So I will show you some paragraphs which concern the admissions and concern the torture evidence. But in circumstances where torture is set aside, the issue of weight in respect of the admissions has to be considered by reference to something else. And there are many possibilities that might go to weight. So one possibility is that the admissions didn't actually happen, and that the documents which evidence those admissions are forgeries. So that's a possibility and a possible explanation for the evidence that the judge has before him. There are other explanations. One explanation, or one example that was given by Shagang in its submissions was the example drawn from R and Ward, the authority at MS2492. So in that case, the criminal division of the Court of Appeal, in a detailed and cogent judgment, explained why Judith Ward's confessions should be rejected as unreliable because of compelling expert evidence that she was suffering from a severe mental disorder when she confessed. So that is an example of the court performing its judicial task perfectly. It found the admissions made to be unreliable by reference to findings of fact and evidence in relation to those admissions. Here, Shagang's only case, though, is torture. At paragraphs 34 to 35, the judge recalls the details of the interview with Mr. Guo, and he records the fact that Mr. Zhu then denies the bribery that he has previously admitted. And there records the torture evidence, but we know that that is placed to one side in the judicial analysis. There is then a third confession from Mr. on the 1st of July 2014. The reference for that is MS1183. It's not addressed in the judgment. It may be helpful just to look at it briefly. What that shows is some further evidence about market conditions. One of the points of criticism made by the Court of Appeal is that the market conditions evidence itself is rather thin in the judge's analysis. That's a point I'm going to deal with when I address the 9 factors. And one sees from this confession that there are more points about the market conditions which are of some significance, namely the fact that Shagang had actually chartered 30 vessels from owners. So it was somewhat of an oversimplification to describe this as simply an owner's market, because Shagang, as head charterer, needed to charter those vessels out. That's what I want to say about that document. Returning to the judgment, the next point is that Mr. Zhu's bail application, this is what we describe as his 4th admission, stroke confession. So the bail application was made on the 22nd of August 2014, see judgment paragraph 37. Leniency is then addressed by the judge, see paragraph 39. And the point about leniency, we say, is in fact understood by the judge. If one looks at the final sentence of paragraph 39, what the judge says is this: however, in the present case, what matters is whether Mr. Zhu's decision to accept guilt was because Mr. Zhu was in fact guilty. So the offer of leniency only takes one so far along the journey. The ultimate question is the question that's posed but not answered in the final sentence of paragraph 39. Was the guilty plea in recognition of underlying guilt or something else? The 5th confession from Mr. Zhu is the admission and guilty plea made before the District Court on the 22nd of September 2015. See paragraph 41 of the judgment. And there, Mr. Zhu was represented by Mr. Guo, his lawyer, who relied on Mr. Zhu's confession when requesting leniency. And the documents are MS 1243 and 1245. So that's a summary of Mr. Zhu's confessions. Mr. Jia T is then addressed. So see from paragraph 45 that Mr. Jia T admitted the bribe on the 23rd of January 2014. So see judgment for paragraph 47, and the reference is MS 218. There are 2 other confessions from Mr. Jia T not addressed by the judge, and if I can just give you the note references for those, that's MS 1109 and MS 1112. As the court may have seen from the documents, Mr. Jia T then absconded after being released. It is right to note that the judge then considered torture at paragraph 49. And the judge then considered or set out the confessions of Mr. Shen. So Mr. Shen, who on HNA's case instigated the bribe, he admitted the bribe on the 16th of February 2014. The reference to that is MS 1116, see judgment paragraph 51. There is also a confession note at MS 1120. And the judge records in respect to Mr. Shen the hearsay torture evidence there at paragraph 52. So the judge has at least 10 admissions from 3 individuals that might be said to tip the scales towards bribery. The judge then has a section of his judgment entitled Confession, Evidence and Torture. So one can put to one side paragraphs 58 to 62, they are not significant. There's a lengthy section of the judgment which deals with confession evidence and torture in general terms, but doesn't deal with the torture evidence in this case. That's not what the judge is doing in this section. What he is simply doing is setting out various provisions of Chinese law which prohibit torture. So it is respectfully a curious section which doesn't actually go anywhere in terms of the relevant reasoning. The judge identifies then from paragraph 83, so MS 224, that his job is to draw conclusions from the evidence, and he recognises the fact that the evidence before him is poor, so a lack of overall evidence. And then the conclusions section appears from paragraph 87. And paragraph 87 states the conclusion. So this is the answer to question 3. On the limited evidence at this trial, and after careful consideration on the balance of probabilities, I find that there was no bribe by Mr. Zhu. We're not saying that he didn't answer the third question. He did. See paragraph 87. But it appears to be fairly accepted by Shagang that paragraph 87 would not be enough to dispose of the case, despite the fact that it does indeed record the judge's factual conclusions on bribery. So the issue is whether paragraphs 88 to 94 constitute adequate reasoning in relation to the second question, namely what weight should be given to the 3 sets of admissions comprising around 10 individual admissions. And Shagang relies before this court on the 9 factors as it did below. And I propose then to turn to those. So paragraph 88 of the judgment deals with factors 1 and 4 of Shagang's case. So Mr. Zhu's guilty plea. So the court will recall then for Mr. Zhu there are 5 admissions, including the admission underpinning the guilty plea, and we will come on to leniency because that is Shagang's 9th factor. But paragraph 88 addresses in terms only the Zhu conviction. So the judge states he can entirely follow the court's finding, and that is presumably a reference to the fact that Mr. Zhu, represented by Mr. Guo, elected to plead guilty. In paragraph 88, the court records the fact that the mainland court did not have evidence of Mr. Zhu also denying the bribery. So they did have the guilty plea and the admission before the court with the lawyer present. But the judge's job, as the Court of Appeal found at paragraph 77 of its judgment, MS 205, was properly to analyse the weight of the admissions by reference to this. And the criticism of the Court of Appeal which we adopt is that it is one thing to identify something that might go to weight. It is quite another thing to then analyse weight in a recognisable judicial manner. So in respect of Mr. Zhu, this is thin in the extreme. It deals only with his guilty plea and puts alongside that the fact of his other denials. That's Mr. Zhu and one of the confessions only. This paragraph we interpret is also intended to deal with Mr. Jia Ti and Mr. Shen. And there, the judgment is skeletal in the extreme, because the extent of the reasons that we receive from the judge regarding the numerous confessions appears to be contained in the words "and others" in the 5th line, which concerns Mr. Zhu's trial, and also what is said in paragraph 89 about the presence of a lawyer. So all we have is the judge saying, well, there is hearsay evidence that they have retracted the admissions, but in fact, where he deals with that in the judgment, as I've already shown the court, so paragraphs 54 for Mr. Shen and paragraph 49 for Mr. G.T. is clearly in the context of the torture allegations. So that's where he deals with those points in relation to those two individuals in terms of the admissions that they actually make. But our fundamental criticism, which adopts the conclusion of the Court of Appeal, is that that is inadequate in terms of analysis of weight. It is simply too cryptic in terms of what the judge actually meant about those earlier admissions from all three individuals. Now, paragraph 89 is factor 2 of Shagang's factors. So the admission, the first admissions by Mr. Zhu, Mr. G.T. and Mr. Shen. And in the case of Mr. Zhu, this is a reference to the admission made on the 22nd and 23rd of January 2014. And the judge refers to the absence of a lawyer. And we accept that this is something which is capable of going to weight, as the Court of Appeal found at paragraph 71, CMS 204. But what of the admissions given by Mr. Zhu with a lawyer present? So he denies the bribe and then he admits the bribe with a lawyer present. We need to understand where all of this goes, and it's simply omitted in the judge's analysis. Paragraph 90 deals with the absence of PSB officers. So this is Shagang's factor 3, and this is a point that was emphasised by Shagang in its oral submissions yesterday. Note, please, that paragraph 90 falls to be read with paragraph 105 of the judgment at MS 226. So what the judge says at 105 is that I should say confine my view at this trial, is also in the interest of leaving proper room for investigation in China by the appropriate authorities to include questioning of the officers who were on duty. I have not set out in this judgment the full extent and nature of the torture alleged to have occurred, but if the allegations were all true, it would be hard to imagine a more comprehensive breach of the duties and responsibilities of the officers. So that is the only other place in the judgment where the judge makes reference to the PSB officers in terms of the conclusions that he is reaching. So my Lord Hodge asked, are we going to deal with infection? This is the convenient moment to deal with it, because we say that those two paragraphs do indeed indicate infection on the part of the judge's reasoning, if that matters to the disposal of this appeal. And one sees that in paragraph 70 of the Court of Appeal's judgment, so MS 204. The Court of Appeal say, it is first worth noting that the judge's finding that the PSB officer's account had not been tested was reached in ignorance of the new evidence that tended to show that their accounts were tested in the PRC. So that is a reference to the fresh evidence admitted by the Court of Appeal, which directly goes to paragraph 90. But the Court of Appeal say this, but that does not really matter, since HNA's challenge simply contends that the judge's reference to the PSB officer's account could only have been relevant to the torture question and not to the issue whether the bribery actually occurred. We agree with that challenge. It seems to us that one consequence of the judge leaving to the end of his judgment his consideration of whether there was torture was to allow him to confuse matters that might be relevant to whether there was torture with matters relevant to whether there was bribery. They go on to say it was also noteworthy that the judge was considering whether at least 3 individuals had been tortured in different circumstances, and yet he did not make a separate finding for each or provide separate reasons for either his finding or his doubts in each of the cases. This may not matter, since the finding that there was torture in none of the cases is not challenged on appeal, but we note that in such a situation it would have been better if the judge had separately considered each of the very serious allegations of torture. So we say that the Court of Appeal was right there and right in paragraph 78 of its judgment to say that paragraph 90 read with paragraph 105 do tend to suggest infection. Now, the court yesterday postulated with Shagang different issues that might suggest good reasons for testing the PSB officer's account irrespective of torture. So my Lord Hambling made reference to possible voluntariness or otherwise of the confessions, and Lord Leggett gave the example of, well, whose story was it? Was the story prompted? So we note all of that and we accept it. But it is entirely speculative on the part of this court as to whether those were the factors that the judge had in mind, because none of that is revealed by the judgment. What is apparent from the judgment is the concern expressed at paragraph 105 about the possibility of torture. So we say that points very strongly towards the conclusion of infection. And in any event, the fresh evidence admitted by the Court of Appeal tends to suggest that the judge's assumption of paragraph 90 was wrong anyway. So paragraph 91, this is paragraph 5 of Shagang's factors, though the market factors has been identified by this court. But here too, we say, with the greatest of respect, that the true import of the market factors in the judge's mind is somewhat vague. So Shagang, as we have seen, was head charterer, disponent owner, but it was locked into future delivery with the actual owners. That key fact is somewhat buried in the final sentence of paragraph 91. Now, just to provide the specific answer to my Lord Hamlin's question from yesterday, so Shagang's head charter with Dong A was for $45,000 per day, but with commission paid by owners to it. That was concluded on the 13th of May 2018. Shagang's charter with GCS was for $52,500 per day, concluded on the 6th of August 2018. Also various commissions, so the net numbers are slightly different. But the actual commercial position of Shagang is an exposure that needs to be hedged or arbitraged. And we say that there is really a somewhat superficial description of the relevance of the commercial factors, as the Court of Appeal found in paragraph 83 of its judgment. So that is MS 206. So what the Court of Appeal says in this regard is as follows, paragraph 83. Whilst we are certain that the admissions deserved greater weight than the judge gave them, we have not had opportunity to hear detailed argument on the admissions themselves, their timing, surrounding circumstances, and provenance. We understand that the judge placed some reliance on the commercial circumstances of the charter party in finding that no bribe had been paid, but we take the view that the way he described those circumstances was somewhat simplistic. To understand whether there was or was not a proper reason why Shagang would want to pay a bribe, we would want to be able to evaluate the decision in some detail. So remission to the trial judge, to a retrial judge for proper examination of that. So we accept entirely that there are market conditions and there are factors which do go on the scale in favour of the no bribe finding. They don't, though, demonstrate why the admissions themselves were unreliable. So again, there is no proper, direct or adequate engagement with the Court of Appeal's second question. It is indirect and inadequate. My Lord. Lord Lambert.
So considering the weight of the admissions, are you saying it's not legitimate to have regard to the plausibility of the facts being admitted?
Yes.
That's what this goes to, isn't it?
So inherent plausibility, yes. So that
Yes.
Inherent probabilities are obviously one of the judge's starting principles. What are the inherent probabilities of the facts before me? And that ultimately doesn't really require any evidence at all. But what he has here then are admissions and market factors which are being put on the other side of the scales. What do the market conditions, i.e. the objective circumstances, actually reveal about the truth of the admissions or why the admissions have been given if they are false? That's the criticism.
Well, they may be relevant to the likelihood of the facts being admitted being true.
Yeah, yes, so they may have some relevance. So to take an example, if I steal £5 and I admit the same, but there is evidence which tends to suggest that I don't need £5, then that is a relevant overall circumstance. But what does that actually reveal about my admission? Why does that demonstrate my admission to be untrue?
Well, those types of circumstances may make it more likely that it is untrue because it's implausible.
But the question is why and to what extent? So simply just stating the fact of objective circumstances and leaving it there ducks the question. So it ducks the question that the judge has is, well, I do have admissions. So what then is the reason for ultimately disbelieving those admissions? And
so you're accepting that these factors are relevant, but you're saying the judge hasn't gone far enough in explaining how he's relied on these factors.
Yes, absolutely. So they are relevant for the reasons that the Court of Appeal gave, but they
well, the Court of Appeal seemed to focus simply on matters going to the reliability of the statement in terms of whether there was a lawyer present and so on, and disregarded the probability factors like commercial context. But you accept that they are potentially relevant, but you say the judge hasn't really explained why and how. Is that it?
If I can ask my lord to go back to paragraph 77 of what the Court of Appeal found, so MS 205. This records in terms that the 9 factors, including the commercial circumstances, etc., are indeed relevant. So see, please, 8th line down. There are a number of reasons why the judge might, in theory, have done so. And we accept that some of Ms. Rose's UC's 9 points do bear on the weight to be attached to the admissions.
So they're saying only some of the 9. But what I'm putting to you is that actually all of the 9 are potentially relevant, but in different ways.
Well, our position is that insofar as the absence of a lawyer is a relevant factor, it could be, but not for the reasons that the judge gave. So that's the infection point. So we accept that essentially anything is relevant. If a judge has an exercise of weighing, then ultimately anything can conceivably be placed in one basket or another, one side of the scales or another. That's not the criticism here. Lord Burrows, my lord.
My understanding of the reasons being given, the 9 reasons, was that some of them were sensibly viewed as going to the weight or reliability of the admissions. The others were simply going to the question of the balance of probabilities in deciding the bribery question, and were not on the weight that you've indicated. So the question of the market position doesn't seem on the face of it to have anything to do with the reliability of the admission. That rather goes separately to the question whether the bribery is proved on the balance of probabilities. Isn't that what the Court of Appeal is saying? Some of these reasons clearly go to weight. The others, and it's all under a heading of his conclusions on bribery, one can accept that it would have made things easier had this all been very clearly and logically approached as the Court of Appeal had suggested. But given that that's not what the judge did, and one's trying to interpret, well, what did he think? Why isn't that the most obvious way of viewing that some of the reasons go to the reliability and some go to the general question of whether there was bribery or not?
Well, I don't fundamentally disagree with any of that. So it is right that there is question 2 and question 3, at least on our case. So there has to be the process of evaluating weight, and there has to be a process of concluding the primary factor issue in terms of bribery. And it's also right to say that you could take those together to some extent. So the criticism is really that we don't know to what extent the weighing exercise has been carried out by reference in particular to the admissions evidence. We certainly do know that a conclusion has been reached from the balance of probabilities as to bribery, i.e. no bribery, but it's that middle ground which isn't properly expressed in the reasons, which leads one to doubt whether in fact there has actually been that proper reasoning process that the Court of Appeal identified. So yes, theoretically, anything can go to any of those two factors, so both the question of weight and the overall conclusion. But there's got to be some cogent examination of all of that, and that is what this judgment is fundamentally lacking in.
Mr. Brown, would that be a convenient point at which to have the 5-minute adjournment before you move on to your next factor?
I'm obliged, my lord, thank you.
Yes, we'll adjourn for 5 minutes. Thank you very much. Mr. Brown, thank you very much for the brief adjournment for resting tired eyes. If you wish to continue, thank you.
My lord, paragraph 92 of the judgment contains factors 6 and 8. The two of Shagang's points. So the first is that Gia H said to Gia T to return the money, factor 6. And the fact of approval of the guarantee by a director who had not been bribed, factor 8. So dealing first with factor 6, Gia T, we say respectfully that this is particularly unsatisfactory, because what the judge is recording is that he is accepting the evidence that there was indeed an admission of a payment to Mr. Gia T, but Mr. Gia H, his father, the relevant officer within GCS, insisted on normal procedures. So this is the only paragraph which deals in terms with the content of the Gia T admission. Paragraph 89 does not do that. And the judge appears to have accepted the accuracy of Gia T's admission. So on its face, he is fundamentally accepting the accuracy of that aspect of the admission's evidence. He is not saying that the admission is unreliable. He is saying the opposite, because the only reason why GH would require the money to be returned is if the money has been paid in the first place. So we say, in respect to that, that the problem goes further, because if the judge is on its face, on the face of the judgment, going to accept that GT received the money, he necessarily had to deal with the admissions of Mr. Zhu and Mr. Shen of Shagang that they had paid the money to him and the consequences of that payment. Shagang's case below, and its case under ground 4 before this court, not now pursued, is that this comment demonstrates no bribe. But our case is that as a matter of evidence, it reveals that a bribe was indeed paid, because it demonstrates that Shagang attempted to bribe HNA. Shagang did not tell HNA about the bribe that it had paid. And what Shagang was obliged to do was to disclose to HNA the fact of the payment made to someone who was in a position to influence HNA's agent, GH. So we say that what on its face is an acceptance of GT's admission makes it very difficult to understand why in the same breath that admission is rejected by the court. So that's what we say in respect of factor 6. In respect of factor 8, approval of the guarantee by another director. Respectfully, again, this is hard to follow, because the fact that the guarantee was approved by someone who'd not been bribed tells you very little about whether others in the decision-making chain may have been bribed. So all that reveals is that the transaction was not uncommercial. It ultimately goes to the commerciality, not to the question of whether there had been a bribe of GH and the admissions of that. Paragraph 93 addresses factor 7. No evidence that the funds used or the expenditure. And the court will have seen from our written case that we make the point that the bribe was paid in rolled up cash in a brown envelope. One sees that on the face of the admissions documents. In any event, it isn't a factor which is sensibly suggestive of no bribe. It doesn't in a cogent way go to the question of the weight of the admissions, accepting the relevance of anything. But what it doesn't do is cogently demonstrate why the admissions should be rejected. Paragraph 94 makes the point that the judge has reached his conclusions on bribery by this point. And then paragraph 94 states, or makes reference to Mr. Zhu's guilty plea, and makes what we would respectfully describe as a cryptic reference to context. But it's totally unclear what the context is that the judge considered to be relevant and material, and he does not say. So that is not a finding that the guilty plea was false, which is the question that the judge had asked himself at paragraph 39 by reference to the issue of leniency. And that isn't a finding that the guilty plea was induced by the promise of leniency, which is Shagang's 9th factor. So turning then to leniency and the promises of leniency, it is right to note that Shagang accepted before the Court of Appeal that the judge had not found that the admissions had been induced by leniency. So see, please, MS 411. So again, this is a transcript of the hearing before the Court of Appeal. And what the Chancellor says at page 69 to Shagang is this. So from line 9, or Justice Foss, no, we have seen that. But I mean, what I was troubled about here in this part is that there doesn't seem to be any actual finding that these confessions were induced by the promise of leniency, which makes it likely they weren't enforced. Possibly that should say induced. Shagang, I agree, my lord, he doesn't make a finding that the confessions were induced by leniency. He's addressing something different. And then further submissions are made in respect of that. And then if I can just ask the court to consider then the further exchange between the Chancellor and Shagang, which begins from line 18 on page 17. And the Chancellor says, how can you say that there was a plausible reason why you might make a confession falsely and then not find that that was the reason, in which case you have to identify the reason in each case. And you know, it's all very well treating all these confessions as if they are generic, but the fact is you have got 3 different people, completely different circumstances, interviewed. Okay, 2 of them were interviewed at the same time by the same people, but 1 wasn't, and different circumstances affecting them. I mean, it's unhelpful to this court not to say what the judge thought. And Shagang says the answer is that it is not part of his reasoning, the finding that there was no bribe. Was Justice Foss right? So that stops at 94. That stops at 94. Right. So what is accepted correctly by Shagang is that there isn't, in fact, any material reasoning in respect of leniency and a possible inducement by reference to leniency. The actual reasons of the judge conclude at paragraph 94. Before the Court of Appeal, it was accepted by Shagang that the 9th factor, leniency or the possibility of leniency, was not part of the judge's reasoning. Now, that then begs the question, well, is the theoretical possibility of false confessions for leniency enough? This is a point that my Lord Legate has raised with me, but one has to bear in mind that that isn't the way that the case was run by Shagang below. So there was no evidence or assertion by Shagang that the false confessions had been made to obtain leniency. So one simply ends up in the same place, namely that anything is a theoretical possibility. I accept that. But what the judge has to do, if he's legitimately going to reduce weight, or the weight of the admissions by reference to that possibility, is to establish some proper basis for thinking that that was or might have been what in fact happened here. But there was no such basis before the judge in this case, and he didn't develop the point. He didn't analyse the evidence in any way which could sensibly support a conclusion that he had, that the individuals in this case had or might have made false confessions out of a desire for leniency. My lord.
Mr. Brown, there were findings, I think, for example, in the judge at 38, that according to Mr. Guo's interview notes, Mr. Xu explained that he decided to adhere to his earlier account because it would lead to a much reduced sentence. So yes. The fact is there was evidence before, obviously hearsay evidence, there was evidence before the judge where he could have found, at least in the case of Mr. Xu, that motivated the confession. But was the judge not entitled to say, well, having not heard Mr. Xu himself and having not heard from any of the direct parties to this other than Mr. Guo, he wasn't going to make clear findings, yea or nay, as to what motivated things?
Yes. Bear in mind, though, that this is 38 and 39 in the context of Mr. Zhu's guilty plea. But the question that the judge correctly poses is in the last sentence of paragraph 39 at MS 217. What matters is whether Mr. Zhu's decision to accept guilt was because Mr. Zhu was in fact guilty. That's what needs to be considered in the context of the promises of leniency, because leniency can be offered, but that in itself doesn't tell you anything about whether the person accepting that offer is guilty or innocent. There's got to be that further stage. And the judge poses the question. He understands that the leniency point doesn't take him far enough, but he does not answer it.
Well, this is all in the context that Mr. Xu was telling his lawyer, I didn't do this, but I'm pleading guilty for this reason.
Yes. So of the 5 confessions, there is the guilty plea at the end of all of that, when Mr. Zhu says to his lawyer, I am pleading guilty for this reason. So that is a factor which falls to be considered. So is that then demonstrative? Does that allow the judge to conclude that the answer to the question of paragraph 39 is that Mr. Zhu was pleading guilty, not because he was guilty, but for a different reason, namely the promise of leniency? That's a necessary question which has to be asked and answered, and isn't by this judge. My Lord Legate had a question.
I just want to be clear, Mr. Brown, about what your case exactly is on the adequacy of reasons, because I understand the principle that a judge must give adequate reasons to be a principle that the judge must explain what the reasons are, the principal factors which have led him to his conclusion, so that you can understand what they are, and if you want to say they're insufficient, you can attack them. Now, a lot of your argument seems to be addressed not to whether the judge explained why he reached his conclusion, but with arguments that the reasons weren't good enough. Now, that's a different form of exercise to engage in, and for that you have to show that they didn't provide any reasonable basis on which a reasonable judge could have reached the decision he did. Now, I hadn't actually understood you to be making that second argument, but much of what you're saying seems to be going to that, not to the question of whether the judge told us so that we could know what his reasons were, and provided that it's very hard to say, I think, that he didn't let us know when he gave 9 factors.
Well, he identified the 9 factors, so that much he did, and he identified a conclusion. So my criticism is not that he didn't tell us that what his conclusion was in respect of the 3rd question, in respect of bribery. So the challenge has always been that we do not know that he in fact engaged in the process of reasoning that would be necessary properly to answer the questions of weight that arose at the 2nd stage. So weight in terms of the admissions and all of the factors. So the criticism is that if he didn't do that, that tends to suggest, so if he didn't provide proper reasons, that tends to suggest that he did not do the necessary analysis, because we simply don't know what factors tilt the scales in what direction and why. So it is not a complaint that we're disappointed because we want to know more about why we lost. The complaint is we cannot safely assume that the judge has done the job before him.
I see, and you're not saying either that the reasons he gave don't provide a basis on which a reasonable judge could come to the result he did.
Well, in a sense, I am, my lord, because if the reasons are insufficient, because they do not demonstrate that he had a basis for reaching his conclusion. So no reasonable judge could approach the third question without properly reasoning his way through the second question. So to that extent, we do say that the reasons fall into the category identified by my lord, insofar as there's any difference.
All right.
We've never identified or pursued this as an English and Emery type pure reasons challenge. So that is not the basis on which we have pursued this appeal. It has always been what the absence of reasons betrays in respect of this judgment. And we say that the absence of reasons betrays a lack of reasoned analysis. So it is a criticism of the process of judicial reasoning, which the Court of Appeal identified was necessary, that we say is not properly disclosed by the judgment. So did the judge properly reason in terms of the second question? We say he didn't, possibly he did, but in any event, we just don't know because he doesn't tell us. So we're left to conclude that he didn't, in fact, carry out the necessary process of reasoning under that second question. And that is how we put it, my lord. So, my lord, turning then to where we are in the judgment, the high point of leniency is perhaps paragraph 97, which, as we've seen, is already accepted not to actually be part of the material reasoning. And that simply refers to a difference in sentence being a possibility, but it doesn't go any further than that. And we say the judge needed properly to test that possibility by reference to the evidence rather than simply identifying a theoretical possibility as being out there. So those are the 9 factors. Note also, though, that the judge simply doesn't address a number of the admissions stroke confessions. So a number of Mr. Zhu's confessions aren't addressed at all in this judgment, including admissions made with a lawyer present. The Shen admission is not dealt with in terms, save for the reference to the absence of a lawyer at paragraph 89. That's all we get in terms of Mr. Shen. The GAT admission is dealt with, but in a way that appears on its face to accept the truth of what is being admitted, not the opposite. See paragraph 92. Dealing then with the final paragraphs of this conclusion, so paragraphs 95 through to 100. So this is all technically immaterial to what the judge actually found. So paragraph 95 makes reference to a challenge by HNA. That should, I think, say Shagang. So a challenge to the reliability of Mr. Zhu's apparent accounts by reference to the dates and times. But ultimately, there's no relevant finding in that paragraph. Paragraph 96 engages with the question about whether individuals can be convicted in criminal proceedings on admissions evidence. That they can, but query where that takes one. And it's unclear what the distinction drawn in the final sentence means, because a confession would clearly be enough to find bribery on the part of Shagang. Paragraph 97 I've addressed in the context of leniency. Then paragraph 97 to 100, 98 to 100 deals with some law in England about the question or the issue of promises of lighter sentences and how those operate in terms of protective English criminal procedural rules. but they don't actually touch on the factual issues. So that's how the judge went about it. So returning then to the Court of Appeal at paragraph 77, and I've taken the court to it. So in light of what I've shown you from the judgment, see please paragraph 77 of the Court of Appeal MS 205. It is clear that each of those criticisms is indeed well founded. So once a judge found that the admissions had not been obtained by torture, if he was going to reject them as unreliable, he needed in our judgment to say why he was doing so. And fundamentally, that conclusion applies whether or not the judge made a finding about torture. But if torture's out as a reason, then that heightens, if anything, the need for the judge to identify what it is that weighs in the balance here in terms of the admission evidence. So there are a number of factors that could allow the judge to reject the admissions as unreliable, but the judge didn't sufficiently address those factors, and he didn't say why he was rejecting them. So as I have shown the court, the conclusion at paragraph 78 is that the reasons are inadequate. So the Court of Appeal accepts that there are some reasons, but they are inadequate to sustain the finding of no bribe in light of the admissions. I've shown the court paragraph 79, the Court of Appeal's conclusion, and the various limbs of that conclusion. So combination of flaws, essentially 5 errors. So first error, judge didn't follow the necessary logical steps. Second error, he failed to ask and answer the correct legal question, i.e. question 2 of 3. Third error, judge ought to have said why he's unable to place any reliance on the admissions if that was his view. He did not do that. Fourth error, he fell into legal error in failing to take all of the appropriate matters into account in deciding the crucial bribery issue. He didn't deal with all of the admissions. The guilty plea was rejected on the flimsiest of grounds. And fifth error, he failed to exclude irrelevant matters, including his lingering doubts as to whether the admissions were procured by torture. And that is a reference to the PSB officer's account, paragraph 90 and paragraph 105. So each of those is an error irrespective of the torture question and the finding of torture, whether there's a positive finding or whether it's simply set aside. So even if the judge was indeed considering the admissions de bene esse, as Shagang suggests, he did not ask and answer the necessary questions that the Court of Appeal had identified in paragraph 65. So those factors, that catalogue of errors, means that there needs to be a retrial if those errors are a sufficient basis in law for overturning the judge. So I propose then to turn to that issue.
Just before you do, please, Mr. Brown, I just want to make sure I got my note right. In relation to what I think you categorised as the fourth error in paragraph 79, failing to take all the appropriate matters into account, you put in that box, I think, a failure to look at Mr. Shen and Mr. Giatti's confessions. Is that right?
Yes, so we don't have a proper and systematic consideration of all of the admissions. So
proper and systematic's one thing, but the position asserted there is there was a failure to take it into account at all.
Yes.
That your position is that it comes as high as that.
It comes as high as that. So in respect of each of those admissions, they have not been taken into account.
Thank you.
So there is some analysis of the guilty plea. There is not an examination of all of the admissions. So what then is the basis of the Court of Appeal's jurisdiction for overturning a judgment in light of these errors? Do these errors, including the errors in respect of reasons and reasoning, if I can use that shorthand, mean that the judgment is wrong for the purpose of Rule 52.21. And the battleground is this. Shagang says there's been an impermissible interference with facts. HNA says, and the Court of Appeal found, that there have been errors in approach. Shagang prays in aid authorities such as Henderson and Foxworth, authorities tab 37, and the Volcave authority as well. And Shagang also makes reference to Lord Hoffman in Biogen, emphasising the point that's familiar to all of us, that a trial judge has the benefit of the impression made by the primary evidence. That's fine as far as it goes, but note that on this appeal, there's actually no primary evidence from any witness as such. And the judge himself identified at paragraph 84 that the evidence was limited. So the live witnesses, Mr. Groh and Mr. Zhang, were giving hearsay evidence. So ultimately, this was a trial which was based to a large extent on inherent probabilities and documents, and that reduces the significance of cases such as Biogen. So we say that this is a species of error that is typified by cases such as Assicurazioni and Datec, and the Court of Appeal recorded at paragraph 51 that Shagang didn't dispute that this was indeed an Assicurazioni or Datec type case. So see paragraph 53 of the Court of Appeal's judgment at MS 199. Like Datec, this is not an appeal against the judge's findings of primary fact. There is no appeal against the judge's finding that the reasons given for the alleged bribe were unconvincing, nor against his finding that the allegations of torture were not made out on the balance of probabilities. Instead, HNA challenges the manner in which the judge reasoned and his conclusion, drawn from his findings of primary fact, that there was no bribe. So we adopt that articulation of our challenge. And I propose to show you, if I may, Datec in the Court of Appeal and in the House of Lords. So the Court of Appeal judgment is at MS Supplementary 29. And the issue before the Court of Appeal in Datec was how to deal with the situation where the challenge is not to a finding of primary fact, but to a conclusion based on evaluations of primary fact, which involve inference and reasoning. And we say, as is well understood, that in those sorts of cases, the judge's conclusions are not sacrosanct on appeal. The judge's evaluation can be subject to scrutiny and correction on appeal. So in Datec, the claim was brought against UPS for a failure to deliver 3 valuable packages. The claimants alleged willful misconduct, namely theft by a UPS employee, which would have the consequence of displacing the limitation of liability under the CMR Convention. UPS said that the reason for the failure to deliver was accident, by reason of the parcels being wrongly mislaid during sorting. The trial judge, Mr. Justice Andrew Smith, conducted a meticulous analysis of the detailed evidence and found for UPS. And the Court of Appeal reversed that finding and found that the reason was employee theft, and the House of Lords upheld the Court of Appeal. And that, of course, is more than the Court of Appeal was prepared to do here, where it has remitted the issue. If I can ask, please, the court then to pick this up in the Court of Appeal's judgment from paragraph 32. MS Supplementary, page number 40. One sees that the Court of Appeal considered it necessary to set out a considerable amount of factual detail, and extensive passages from the judgment of the judge are adopted together with some points made in the course of argument. And then the Court of Appeal do precisely that. So detailed examination of the underlying facts, which appears from paragraphs 33 onwards. I'm not proposing to take the court through the details of the facts there, If I can ask the court, please, though, to turn to paragraph 53. One sees the submissions made on appeal. Mr. Reeve makes no complaint about the judge's overall approach. He accepts that the judge was correct to treat the claims as having the burden of proof to the balance of probabilities. In the absence of direct evidence, it was necessary to consider the relative probability of employee theft against the probability of loss through other causes. In conducting that exercise, the judge was right, as he stated in paragraph 67, to adopt a properly rigorous approach to such evidence as is available, in accordance with the observations of Lord Justice put in Lacey's footwear. In paragraph 68, the judge took proper account of what was said in Re-H about the burden of proof. That is right to conclude that an allegation of theft is not so improbable that there's a particularly heavy burden upon the claimants to prove their case. Now, if I can ask, please, the court to read paragraphs 54, 55, and 56 before I continue my submissions. So, my lord, in a nutshell, judge asked the right question, but the judge went wrong in answering that question. That was the appellant's case, ultimately accepted. So the court records the submissions of the respondent from paragraph 62 onwards, deals with the point in relation to the Poppy M and limited evidence and probabilities, and the Court of Appeal correctly records at paragraph 66 the observation as to the necessity of respecting the primacy of the trial judge. At paragraph 67, having recognised all of that, the Court of Appeal, or Justice Richards, says, in my judgment, the case advanced by the claimants has considerable force to it. There's sufficient evidence about the free data packages and the surrounding circumstances to enable the court to engage in an informed analysis of the possible causes of the loss and to reach a reasoned conclusion as to the probable cause. It makes reference to the experts, but the judge, the Court of Appeal recognises that it has got the tools for the job, including the benefit of the judge's meticulous analysis. See then what the Court of Appeal does, please, at paragraph 77 through to 78. Paragraph 77, so MS supplementary, page number 62. I'm inclined to agree with the appellant's submissions concerning Mr. Kadim's subsequent conduct and explanation to the police, and to place less weight on them than the judge did. But the explanation of employee theft does not depend for its cogency on putting the blame specifically on Mr. Kadim or on otherwise identifying the responsible employee or employees. The explanation fits well with the known facts, even though the employee or employees concerned cannot be identified. So the Court of Appeal considers the weight that has been attached to the rival theories and the evidence by the judge, and disagrees with the judge's conclusions in respect of weight. So C, please, the conclusion at paragraph 79. Looking at the matter overall, it seems to me that the judge did overstate the factors telling against employee theft and understate the factors telling in favour of it. I consider employee theft to be a much more likely explanation than the judge found it to be. Perhaps more importantly, I regard as implausible and improbable the explanations of accidental loss to which the judge referred when concluding that accidental loss was more likely than employee theft. So even building in appropriate deference to the judge, there is no barrier to the Court of Appeal reaching the conclusion that actually the judge has gone wrong for the reasons that it gives. So C, paragraph 79, C, also paragraph 82, MS supplementary page number 63. I have borne very much in mind the observations of Lord Justice Brooke in Lacey's Footwear, with which I am in respectful and total agreement as to the need for a properly rigorous approach to the available evidence. It is the evidence properly analysed which, in my view, leads to the conclusion and sets out some disagreement with the judge. That's not the answer to the appeal, though, because the Court of Appeal recognises that there's a further exercise to carry out, namely, is that all enough? And that's what the Court of Appeal addresses at paragraphs 84 to 85 of its judgment. So there remains, however, the question whether it is right to interfere with the conclusion reached by the judge on this issue. An appellate court must exercise caution in such matters for reasons discussed in Assicurazione. The constraint applies with particular force where the conclusion is one of primary fact and where it depends to a significant extent on oral evidence and the view that the judge formed of the witnesses. That, however, is not a material consideration in the present appeal, since there's no issue about the judge's findings of primary fact. So paragraph 85 sets up the issue. The issue here depends on an evaluation of the primary facts and the inferences to be drawn from them. And then the Court of Appeal cites Lord Justice Clark in Assicurazione and Lord Justice Ward at paragraph 197. So all of that is encompassed within our appeal, or within our appeal to the Court of Appeal. And as the Court of Appeal, or Justice Richards identifies at paragraph MS, page number 64, bearing in mind the considerable force and the importance of all of those points, nevertheless, here, on the facts of this case, the trial judge had indeed gone wrong, and the Court of Appeal was itself in a position to carry out the exercise correctly. So you see the conclusion at paragraph 89, and Lord Justice Sedley and Lord Justice Brooke both agree with that. Turning then, please, to the House of Lords. So was that legitimate? So NS 1464. My Lord.
But this is quite a different situation, isn't it, the Datek case? Because there's no criticism, it'd be surprising if there was, of the meticulous approach that Mr. Justice Andrew Smith took and the fact that he engaged with the issues. The criticism was that he came to the wrong result and that his conclusion wasn't justified.
Yes.
And that's no longer part of your case. Your argument is a completely different, is a quite different complaint, that the judge didn't engage, as I understand it, in a proper analytical process, not that he reached an unsustainable conclusion.
My Lord, our case is fundamentally that he reached an unsustainable conclusion in respect of the bribery issue because he did not carry out the reasoning that was necessary for him to reach that conclusion. So that our case is and always has been that conclusion is unsafe for those reasons. So I appreciate.
But is it, you're saying that his reasons were insufficient, and led him to a wrong result, or?
His reasons were insufficient, and that tends to demonstrate that he did not carry out the analysis. And we say, but it is a matter for the retrial, that he reached the wrong result.
Okay.
My lords raised this issue in terms of reasons with me once or twice. I perhaps should emphasise that the challenge to the reasons is certainly encompassed within our challenge to the reasoning, and always has been. So that is live on this appeal. Now, I appreciate that there are differences, of course, with DATEC, because in a sense, there's 2 points really. The first is that in DATEC, there is a comprehensive and meticulous judgment, and with respect, one does not have that here. What one sees in the House of Lords judgment is that that in effect enables the Court of Appeal to do what it ultimately does, which is decide the matter the other way. Because this judgment is respectfully not detailed and meticulous, the Court of Appeal, as it recognised in the parts of the judgment which I have shown you, did not feel confident to do that. We invited them to do that, but they resisted that invitation, declined that invitation on the basis that if there's going to be a proper process of reasoning, that has to go to a judge, has to go back to the commercial court for proper reasoning and reasons to be given. So those are 2 points of distinction with DATEC, but fundamentally the DATEC point is, well, is this a basis for interfering with the judge's judgment? Because Shagang's submission on this appeal is that, notwithstanding what we say, you still shouldn't overturn the judgment, because ultimately, because these are all encompassed within factual findings, this is not the proper remit of the appellate court. And it's by reference to DATEC that we say that that submission is wrong. So picking up what Lord Mount said in the House of Lords, with whom Lord Hoffman, Lord Hope, Lord Walker and Lord Newberger agreed, Lord Walker, it is right to note with a slight wobble, see paragraph 13 of the judgment, but ultimately concurring in the outcome. Lord Mance's judgment begins at paragraph 14 and deals with the willful misconduct point on paragraph 32. And paragraph 42 summarises Lord Justice Richard's judgment, and it includes most of what I showed you from the Court of Appeal, but not everything, which is why I took you to the Court of Appeal. Paragraph 45 records what is said by what is now the appellant, so UPS. The Court of Appeal, in concluding that employee theft was a relevant cause, paid insufficient attention to the primacy of the judge's findings, was lured into a process of elimination, which could at best arrive at a conclusion as to which of many possible causes was the least unlikely, rather than a conclusion as to any cause which was more probable than all the others viewed together. But despite lip service to the need for clear and cogent evidence, it found willful misconduct when there was an absence of such evidence. So the middle part of all of that, about eliminating all possibilities and seeing what you're left with, isn't an issue on this appeal, but certainly the other parts are. And that fundamentally is not accepted by the House of Lords. So paragraph 46 sets out the authority then of this court, what the correct approach is of an appellate court to findings of and inferences of fact made by a judge at first instance after hearing evidence. So no disagreement between counsel, it is assicurazione. And we adopt with respect all of that as the correct statement of the law and a statement of law that is applicable here. So one sees 14, 15, 16 and 17 of assicurazione read into the judgment, and in particular paragraph 17 refers back to an earlier judgment of Lord Justice Mance, as he then was, in Todd's case, which drew the distinction between challenges to conclusions of primary fact or inferences from fact, so primary and secondary evidence, and on the other hand, the evaluation of those facts. Lord Mance there identifies the procedural rule, so the word review, which is now in Rule 52.21.1, tends to suggest that an appeal is concerned with things like the correctness of the exercise of evaluation. And we would say that the correctness of the judicial exercise includes the exercise of judicial reasoning. So the reasoning and the reasons given, not just the actual outcome. And Lord Mance says, by reference to CPR, which is now CPR 52.21, 3 and 4, the reference to the word wrong in those provisions and those provisions in general demonstrate that the jurisdiction of the appellate court is a wide jurisdiction. And the approach in those cases is set out in those paragraphs, so over the page to the top of 1348 of the judgment. So fundamentally, when permission has been granted, the appellate court must make its own mind up. That's its job. It will give weight to the advantages that the judge had, but if those advantages were in truth minimal, then there's little weight to attribute to them. And the principle of deference to the trial judge reflects ultimately the advantages that the trial judge had in conducting the trial and seeing the evidence firsthand, but it's up to the appellate court to decide whether the judgment was wrong, having balanced the advantages that the court had along with all of the other evidence. So see, please, also paragraph 47. Whatever the threshold here, whether that appeal is correctly described as being inferences or general review, then it is clear, or was clear, that there had indeed been a breakdown in analysis on the part of the judge. And then Lord Mance records what Lord Justice Richards said from paragraph 49. Basically, the judge failed to give proper weight to the various factors in play, or he attached the wrong weight to them. And as Lord Mance records at paragraph 50, the judgment of Lord Justice Richards was compelling and justified the reversal of the trial judge. So our simple proposition is that DATEC demonstrates the width of the procedural rule in question. Deference is indeed factored in to the analysis at every stage. But the appellate court's function goes further. It must review the judgment, it must test the judge's approach, and it is necessary for there to be cogent evidence in support of the judge's finding. So all of those points we say are correctly identified and apply here. Very briefly, if I can show you a further example, which is Symmetra, so MS2644. So judgment of the Court of Appeal, Lord Justice Nails. So see, please, the submission of the appellant at paragraph 6, which is ultimately accepted to be well-founded. Paragraph 7 records the defence of the respondents of the judge's judgment, and the Court of Appeal correctly identifies, by reference to Volcave, the approach be adopted by the appellate court. So see, please, paragraph 37 of the judgment, MS 2649. But the Court of Appeal makes a point at 38 that that's not the approach here. It's not really that sort of case. There, the challenge is to reasons and whether the judge properly took the evidence into account. It's not identical to this case, it's a different formulation of the challenge. The Court of Appeal from paragraphs 39 to 47 addressed the nature then of the review. And this is specifically addressed by reference to reasons. But the Court of Appeal makes the point that reasons have different purposes within litigation. And so the point I've hopefully already made to this court, HNA needs to know why it's lost. That's included within the price of the ticket when it comes to the court. So see paragraph 39. But also it goes further. Inadequate reasons are more likely to betray some other error, such as a failure properly to test the evidence. And see the examples given by the Court of Appeal from paragraph 41 onwards, which makes reference to the fact that the court needs to have proper building blocks of evidence. And then the court from paragraph 46 and 47 sets out ultimately some fundamental principles which would be necessary in order for the judge to discharge his duty. You see what is said there, paragraph 46, MS 2652, without attempting to be comprehensive or prescriptive, not least because it's been said many times that what is required will depend on the nature of the case and there's no universal template. I would make 4 points which appear from the authorities and which are particularly relevant in this case. First, succinctness is as desirable in a judgment as in counsel submissions, but short judgments must be careful judgments. Second, it's not necessary to deal expressly with every point, but a judge must say enough to show that care has been taken and that the evidence as a whole has been properly considered. Which points need to be dealt with and which can be omitted itself requires an exercise of judgment. Third, the best way to demonstrate the exercise of the necessary care is to make use of the building blocks of the reasoned judicial process by identifying the issues which need to be decided, marshalling, however briefly and without needing to recite every point, the evidence which bears on those issues and giving reasons why the principally relevant evidence is either accepted or rejected as unreliable. Fourth, and in particular, fairness requires that a judge should deal with apparently compelling evidence where it exists, which is contrary to the conclusion which he proposes to reach, and explain why he does not accept it. We respectfully adopt that, including the prescription that this is not a template. This is ultimately just identifying the fundamental building blocks of any judgment. And the court there concluded that applying that approach, the judgment was indeed deficient because there were not clear findings on parts of the principal factual matters which were relied upon. See paragraphs 141 to 143 of the judgment. And the Court of Appeal also concluded that the judge had failed to analyse or consider material evidence. See paragraphs 145, 168 and 188. So we say that in that case, as in the present case, the Court of Appeal in each has built upon well-established practice of the appellate courts, up to and including this court. And on application of that approach, they correctly concluded that the judge had indeed erred because the admissions evidence was not properly evaluated, and the Court of Appeal was entitled and was right to send the bribery issue back to the commercial court for that reason. So that is so irrespective of the actual grounds of appeal, to which I will turn to now and will deal with fairly briefly. So, my lord, if it is convenient to the court, I will carry on for 10 more minutes to 1 o'clock. We're making good progress. I'll then be in a position to finish the first part of what's left shortly after lunch, and the spoilers will follow on specifically in respect of A number 2.
That's fine. Because we started later this morning due to technical difficulty, which you witnessed, you have to 3:15 rather than 3 o'clock, which would have been your terminus viewing the matter last night.
My lord, I'm grateful. So, Shagang's second issue, the scope of the retrial and whether there was indeed a finding of no torture. So what the Court of Appeal in fact found is set out at paragraph 91, MS 207. And the Court of Appeal provides additional reasons in response to written submissions that were provided by Shagang following the draft, where Shagang said there was an obvious error in paragraph 60 of the judgment, which I've taken the court to. And the Court of Appeal say this: our judgment stated that Northstate had been unable to find on the balance of probabilities that the admissions had been obtained by torture. When Shagang submitted, he had actually made no finding as to whether or not on the balance of probabilities the admissions had been obtained by torture. Accordingly, Shagang asked that we should remit the question of torture to the judge for hearing the matter. In our judgment, Shagang misunderstands our decision. We have determined that the judge ought to have decided the question of torture before he decided the question of bribery. In fact, as we say above, he did not. He may have avoided deciding the question of torture partly for the inappropriate reasons he gave in paragraph 105, but his judgment made clear that whilst he could not rule out torture, he had not found it proved on the evidence. Had he found it proved on the evidence, he would not have used the language he did. We have held that the consequence of this approach, as a matter of law, was that he had not found torture proved. Shagang is seeking an inappropriate second bite at the cherry, and it did not appeal the refusal to find torture. We say that that is unimpeachable. The judge did not find torture to be proved on the evidence, and nobody suggests otherwise. What the Court of Appeal did was to hold that the consequence of the failure to find torture proved as a matter of law was that he had found torture not proved. And that is on the basis of Lord Hoffman's judgment in Brief B, and paragraph 2 in particular. If necessary, torture had not been proven by Shagang because Shagang bore the burden of proof on torture and failed to discharge it. So, in other words, the legal consequence of the judge's failure to find torture proved was that he determined the pleaded issue of torture against Shagang. And that is why the Court of Appeal said that remittal of the torture issue would have been a second bite of the cherry, because Shagang did not cross appeal, my lord.
What is your answer to one of Lord Panic's points, which is that if the judge did such a bungled job that it had to be sent back for a retrial, it can't be right to limit the matters which the different judge on the retrial is allowed to consider in reaching his conclusions?
Well,
it does seem to pick out the bits you like from the judges on your submission, inadequately analysed judgment, and send back the bits you don't like.
Well, my lord, let me put the position this way. We complained about this judgment and identified what we said were the errors in our original appellant's notice, and we identified the re-B point, namely that there has indeed been a determination of torture in terms of the judge's analysis. So Shagang were on notice as soon as we lodged our original appeal before the judge and subsequently renewed to the Court of Appeal, that this was the correct analysis of the judge's judgment. He had indeed, whatever he thought he might be doing, determined the question of torture. If Shagang disagreed with that, then they have an opportunity to cross-appeal that. they can make their own decisions about how to conduct this appeal. And if they consider that we're right, but on a protective basis, then they want to cross-appeal it against that. That's a matter for them. But they didn't do that. So they are left with the consequences of their decision if we are right that there has indeed been a determination of torture. Now, Shagang's starting point is that the judge didn't actually find anything about torture. So just dealing with that, we say that must be wrong. So the judge didn't say that he was setting torture aside, or that he didn't consider that it was necessary to address it at all. On the contrary, he said the opposite. So see paragraph 5 of the judgment, he identified torture as one of the two facts in issue. As I've shown this court, there was then a lengthy passage in the judgment, the confessions, evidence and torture section of paragraph 63 and 82, so MS 220 to 223, in which the judge clearly thought that he had to determine questions of torture. Otherwise, what in fact is the relevance of all of that? That is then followed by the judge's passage, which is entitled Conclusions from the Evidence of Trial, which we've looked at. And the judge referred to the need to reach conclusions on the issues in the case. And the issues in the case had been identified by the judge at paragraph 5 as being bribery and torture. So he didn't say, I'm not going to decide torture, and then proceed de bene esse. On the contrary, what he's doing on the face of his judgment is to say that he is going to make findings in respect of torture, because following on from his conclusions on bribery, we have the section of the judgment which is headed Conclusions on Torture. So it is not right for Shagang to say as their starting point, actually he just didn't decide it, because he clearly did. Otherwise, what is the purpose of his conclusions on torture? So what then is his conclusion? See paragraph 101. His conclusion is that torture can't be ruled out. So that is a definitive conclusion on the part of the judge that he can't rule torture out. The issue is, well, what does that mean as a matter of law? So it is identified as a finding. It's based on the evidence for and against. What we say is that that is properly forced to be interpreted then as an actual reasoned conclusion on torture. And then one has to consider what the significance is of 3b. So where there is a finding on a fact in issue where a party bears the burden of proof, there are only two options. Those are 1 and a 0. A finding that a fact cannot be ruled out is in law a finding of 0, as the Court of Appeal correctly recognised. My lord.
Can I just be clear as to what you understand the Court of Appeal actually saying when they say the issue goes back without the question of torture? Do you understand that to mean that a trial judge, in weighing up the confession evidence, cannot take into account a risk that it was obtained by torture, that risk being between 0 and 50%? Or do you not read the Court of Appeal as ruling that out?
No, that is ruled out. So we do indeed read the Court of Appeal correctly as applying the approach required by VB to the two facts in issue. So having determined it for the first issue, the exclusionary rule, and of course we'll come back to this probably after the adjournment, can it come back in through the back door when it comes to questions of weight? And we say that the very clear answer to that question is no, it cannot. Because the value of 0 has been returned for all purposes within this trial.
Thank you.
My lord, I wonder if that's a convenient moment And then I'll resume specifically with read B after the short adjournment.
Yes, if you're moving on to take us to a case, there's 1 minute to go. That would be a convenient point at which to adjourn for the short adjournment. Thank you very much.
Lord.